Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals held in and for the state of New York may now draw near, give their attendance, and they will be heard. Please be seated.
Good morning, everyone. Judge Rivera is participating remotely in oral argument. This is appeal number 60, Harkenrider versus Hochul. Counsel?
Good morning, Madam Chief Judge and members of this honorable court. My name is Craig Buckeye from the law firm of Phillips, Lytle in Buffalo, New York. On behalf of Assembly Speaker Carl Heastie, before I begin, I would like to request 2 minutes for the purpose of rebuttal.
You may have 2 minutes. And let's start here, counsel. We do have an affirmed finding from the appellate division below. What is the standard of review, sir?
The standard of review is that the petitioners needed to prove their case beyond a reasonable doubt. And this is the standard that was upheld only 35 days ago by this court in White versus Cuomo. And in particular, what I would note is that this is more than a case about redistricting.
But counsel, I'm sorry to interrupt you, but that's the standard of proof. I think what the Chief Judge is saying here is we now have affirmed findings of fact in this record. So what's our standard for reviewing affirmed findings of fact?
Well, the Court of Appeals is a court that reviews findings of law rather than findings of fact, but what we would submit is that what the court needs to answer is whether the evidence was sufficient enough in order to support the findings.
So a legal sufficiency.
Legal sufficiency.
But on that standard, aren't the petitioners then entitled at this stage of the litigation to every fair inference that can be drawn?
And I would say, Judge Garcia, I would emphasize the word fair in terms of fair inference. And so one good example is, and what I'd like to refer to is the majority opinion, the plurality opinion, wherein it was inferred, and the inference was the word that they used, that because it was only Democrats who voted in favor of the congressional plan, that therefore it must have been for some partisan purpose. We would submit that that is not a fair inference because it can also be inferred that rather this is a circumstance where people in the legislative minority, the Republican minority, they had 3 days under the bill aging process to propose amendments. They had an opportunity to engage in substantive input, and in fact, the record demonstrates that Republican input was considered, and what I would commend the court to is pages 3263 to 3265 of the record, because we have in the record the maps that came from the Independent Redistricting Commission the first go-around when they actually did produce maps, and what one will find, for example, is that in looking at the various communities of interest and in order to try to keep them together, concerning the upstate map, they decided that there should be a Metro Buffalo district, there should be a Metro Rochester district, that Metro Syracuse should be included with Tompkins County because those are the two college towns with Ithaca and Syracuse, and Metro Albany should have a district. And there was marked similarity between and among the plans, and in fact Justice Lindley noted that at his oral argument, but yet the plurality threw out the baby with the bathwater, so to speak, and said we're going to invalidate the entire map.
Counsel, are communities of interest analogous to geographic locations? You just spoke about Albany, Schenectady, Rochester. Is that what it means, or is it broader than that?
It's broader than that. It can mean geography, but it also can mean communities of interest in terms of religion. It can mean communities of interest in terms of language. It can mean communities of interest in terms of ethnicity. And a very good example is what happened with respect to the map as drawn in District Number 11. The Staten Island district, so to speak. Surrounding that Staten Island district, the decision was made in order to account for the fact that there is a burgeoning Asian American population in Brooklyn, in Bensonhurst, and Bath Beach, that pursuant to the testimony of Dr. Hua Li from the Organization of Chinese Americans of New York City, that the Chinatown of Manhattan and the Chinatown of Brooklyn should be united in a single district. And
so it could be ethnicities as well.
Yes, absolutely.
So if you want to follow that exhortation in the Constitution, I think it's to try to maintain communities of interest. I'm not sure. You can correct me on that. But does that have to yield to to other commands such as compactness and, contiguousness and things like that?
Well, contiguity is an absolute must. It is impossible to have districts that are not contiguous. But aside from that, we would submit that the appropriate metaphor to use in this circumstance is the metaphor of a scale. And we don't have a typical scale with one side and another side, and like in a science class. This is a scale with multiple sides to it. And it's the duty of the legislature to decide how to balance all of these required criteria that they need to consider. How to balance, for example, keeping communities of interest together. How to balance maintaining the cores of pre-existing districts. How to balance keeping counties and cities together. And honoring jurisdictional splits.
Well, it was the duty of the IRC, right, initially at least, not the legislature?
Initially, it was the duty we would submit
and
to...
so they didn't do their duty, or did they?
They did not do their job. They did their job the first time around in
So
terms of...
in your view, it was okay to submit 2 competing plans. That complied with their duty?
Yes, if that's what they wanted to do, we certainly have no problem with that. Both of those plans were rejected. And so then it went back to the Independent Redistricting Commission to produce a new map, which they did not do. And we would submit that a fortiori, the legislature retains all of the prerogative that it had in the redistrict.
Counsel, if I can ask, I'm on the screen.
Yes, Judge.
Let me just follow through on this question, on this point you're making. I understand it fully, and I appreciate the constitutional foundation for the argument you've just made. But why isn't it also appropriate to say the IRC could have fulfilled its duties under the Constitution because it submitted 2 maps? That's what it did. And then the legislature could have assumed that that's all they had. Could have treated it as a constructive submission the second time around when they didn't give anything else because they've already given the 2 maps. They're deadlocked.
I think that's a salient argument, and that argument could be made. I mean, it hasn't been made before by the parties, but we would certainly recognize the wisdom of that argument.
Well, in that scenario, which map would you consider the first submitted and which would you consider the second?
Well, they were submitted simultaneously. And so the way it happened
Well,
was...
the constitutional amendment lays out dates and deadlines.
It does.
So I'm just trying to figure out if we go down that road, do we take the Democratic map first and then consider the Republican after, or vice versa?
Well, it's probably a metaphysical question because they were submitted at the same time.
And both rejected.
And both were rejected, yes.
But counsel, following up on Judge Rivera's point, the legislature could have done that. They could have accepted the initial 2 plans as the second submission and applied a 2% rule to those plans for amendments, and they didn't do that. They did something very, very different. And isn't that evidence of a purpose to gerrymander?
No, not at all. And the reason for that is that, purpose suggests some kind of intent. And the other states that have been talked about in this litigation, Ohio, Florida, Pennsylvania, we have seen evidence of what qualifies in order to satisfy a purpose to favor or disfavor a political party. There's usually a partisan symmetry analysis, for example. Sometimes, as in Ohio, you have direct evidence. In the state of Pennsylvania, also there was a very robust compactness analysis as opposed to what we had here from Mr. Trendy, where he could only use one compactness metric, otherwise his program wouldn't necessarily work. And so, and in fact, I would commend the court to Mr. Hecker's letter submission that goes through all of these ways that purpose could have been established. And so all we have here are, number one, what the plurality said is the fact that this map was only adopted by Democrats without Republican votes. Number two, they make an inference that, in fact, there was no Republican input at all, which is not true based upon what's in the record from the commission. And then they go to the simulations of Mr. Trendy, and those simulations are extremely flawed in terms of their problems with redundancy, the problems with the lack of an appropriate sample size, the problems with the lack of an appropriate analysis that's not nearly as robust as the analysis he was doing at the same time in the state of Maryland.
So, counsel, let me ask you, I'm on the screen. Those points that you're making about the deficiencies, as what you see as the deficiencies in the Trendy analysis, why doesn't that go to the weight And apropos of the questions that were asked by members of the bench before, why isn't that sort of findings of fact that we can't get into?
We would say, to quote the dissent from Justice Whalen, that this is not a case where one would have a battle of the experts, so to speak. This isn't a situation where Mr. Trendy has some simulations and respondents' experts have some simulations, and it's a matter of evaluating which simulations might happen to be right. Mr. Trendy's simulations are the simulations, and respondents did not use their own simulation method because we would submit we didn't have the burden to do that. And so the question remains, with respect to Mr. Trendy's analysis, was that enough? Was that legally sufficient? Because we don't have a battle of the experts. All we have is Mr. Trendy, and we would submit that the sufficiency simply is not there to overturn the reasoned judgment of the legislature, which, as this court said only 35 days ago, that the court is cognizant of in order to maintain the distribution of powers that render it improper for courts to lightly disregard the considered judgment of a legislative body that is also charged with a duty to uphold the Constitution. And in fact, as the dissent noted, it is a pretty far leap to say that the legislature, based on some inference, must be presumed to have been derelict in satisfying its constitutional responsibility. And we would submit that the landscape of the law has not changed in 35 days, nor should it change.
Thank you, counsel. Counsel?
Good morning, everyone. May it please the court, Eric Hecker from QD Hecker Wong. I too would like to reserve 2 minutes with the court's permission.
You may have 2 minutes, sir.
Your Honor, the standard review is de novo, and that's because the question before the court is whether a statewide statute is unconstitutional. By definition, that presents a legal question that this court does not show deference to.
Wouldn't that be the standard of review for a direct appeal, whereas in this case, we have an intermediate appellate court reviewing findings of fact?
I don't think so, Your Honor. Either way, the question is whether the statute's unconstitutional, which presents a question of law. And to be sure, some questions of law are what we call pure questions, and some have factual issues embedded in them, not unlike the court's gambling case from a few weeks ago. But the fact that there may be, I mean, it's not like the question is whether the light was red or green, and 5 witnesses said it was red, and 3 said it was green, and 1 was wearing their glasses, and the other had a
No, the
drink.
question is whether the legislature acted with partisan intent or not. And
Correct.
intent is a quintessentially factual question.
In a different context, for sure. In this context, it drives the legal question of whether the statute is unconstitutional. Either way, there really is no persuasive evidence on any standard that could carry their heavy burden here in concluding that intent. And I'd like to take head on the appellate division's statement on page 7 of its decision that it is implausible, even if it accepts, which the plurality seem to be taking steps towards accepting, that the first 4 bands to the left of Mr. Trendy's dot plots show a space between the enacted plan and the simulated bands precisely because he ignored and in fact wasn't even aware of the strong bipartisan consensus on the commission that the legislature heeded about how to draw upstate. The critical point is that the very same problem plagues the next 9 columns to the right in the so-called competitive Democratic districts. The districts that we're talking about there are districts like Albany, Rochester, Syracuse, the upstate urban areas that Mr. Trendy didn't even know and ignored that the commission, Republicans and Democrats alike, had decided to draw bluer than Mr. Trendy's simulations did starting from a blank page, not to make them blue, because one of the many ways to acknowledge and heed a community of interest is to talk about keeping an urban population.
But counsel, I'm on the screen, but counsel, I understand this argument you're making, and it's certainly a compelling argument about the benefits of the IRC process. But what's challenged is the legislatively drawn maps and what the legislature adopted, which was not what the IRC proposed in either of the plans. So isn't the question really just about what the legislature did, not whether there were some parts of the plan that even Republicans would find appropriate?
I appreciate the question, Your Honor, and this to me goes back to one of Judge Garcia's questions, where he suggested that what the legislature did was very different, and I would respectfully disagree. There was no consensus, Judge Garcia, about downstate at all, and there was a very clear consensus about upstate,
But
and what the legislature did closely hewed to that.
My point on that wasn't to get into the details of the map, and there are arguments on the sides of the map and the expert testimony. My point in that questioning was, we need to look at, I think, what the process was. We can all agree, I think all agree, that the IRC process broke down. They didn't do their job, or however you want to phrase it. And then it went to the legislature. And what did the legislature do? So there were a number of options open. They could have, I think as Judge Rivera suggested, taken one of the two plans that had already been submitted and substantially complied with the process. I think at that time, by applying the 2% rule that was in effect by their own legislation. But they didn't. They didn't do that. They did a number of other things. So one thing they did was propose a constitutional amendment passed entirely along partisan lines that would have given them the plenary authority, apparently they already claim they have, and gotten rid of some of the supermajority requirements for one-party rule. That didn't pass. They passed a law to get rid of the 2% notwithstanding, so the 2% didn't apply, and they came up with their own plan in a process that didn't involve the other political side. It was a partisan process. Again, I'm not saying any of that violated per se a rule, but if we're looking at purpose, don't we look at that track record?
In part, Your Honor, but what got buried in there is looking at the map. And that's what the lower...
But you do look at the map, and that's part of the evidence of purpose. But I think as the Florida court made clear, our statute isn't an effect, our constitutional provision isn't an effect statute or constitutional provision. It's a purpose provision. So what we're looking at is motive. And effect is circumstantial evidence of motive. But so is action. And the actions the legislature took, I would suggest, also speak to motive here.
For sure, Your Honor, and if I could address both, the process and the map. The process that was followed here is a far, far cry from what happened in Florida, where you had outside political operatives hired to engage in sham proceedings and to destroy material evidence. We don't have anything within a mile of that here.
Do we know what the process was here? I looked in the record and I saw no discovery in terms of what actually happened in drafting the maps.
We produced discovery that's not in the appellate record, but it's in the discovery record showing that there were no outside political consultants and the map was drafted by legislatures and their staffs. Even if you could infer some basis to divine intent from the fact that with only a month to go before the petitioning period and with a fully developed record already voluminously prepared and transmitted by the IRC, and more than enough votes to meet the constitutionally prescribed threshold to act, that the legislature acted, even if you could infer something from that, you have to get to the map, Your Honor. This would be the first court in any of these cases to strike down a redistricting plan without doing a district-by-district analysis of what the supposed problem is. They chose to proceed the way they chose to proceed. They put all their eggs in the basket of Sean Trendy, whose bans don't make any sense because he didn't take into account communities of interest, and Mr. Lavinia, a gentleman who is so wrong about everything, he's become a ghost in this case, and there's nothing left. And so if Your Honor is put off by the process more than I am, I would respectfully suggest there's just not anywhere near enough to get them beyond a reasonable doubt.
Thank you, counsel.
Thank you.
Counsel?
Thank you, Your Honor. Jeffrey Lang, on behalf of the governor, I'd like to reserve 2 minutes for rebuttal.
Of course, sir.
I'd like to address first the standard of review. I agree with my Senate colleague that the standard is de novo, and the reason for that is that I don't think what happened here is properly considered an affirmed finding of fact. It is true that there were facts that were relevant to the overall, determination, but the determination was a legal one, which was a declaration by a court that these electoral maps were invalid. I mean, it's certainly true in other cases. For example, the intent of the legislature can be relevant to whether a law is constitutional, if it's passed with religious animus or if a law is passed with discriminatory intent. So, that is an intent issue, but that doesn't render, and there could be facts that are relevant to that, to deciding that issue, but that doesn't render the overall conclusion a factual one. So I think what happened here is best considered an affirmed conclusion of law that this court can review. And I would also add...
Oh, counsel, can I ask, I'm on the screen. I just want to tease this out a little bit. Are you in part arguing that regardless of the intent, the bottom line is, if the district lines are not gerrymandered, you don't have an unconstitutional redistricting? You don't have the apportionment, the lines are not unconstitutional, because what the Constitution prohibits is an attempt to do that, and if you didn't succeed in that, you haven't violated the Constitution. Or have I misunderstood your argument?
No, I agree that intent is the issue. All I'm suggesting is that what's really important is the context in which that finding is being made. And in the context, just like as one could find a discriminatory intent in passing a law or passing a law with religious animus, and I don't think this court would say, well, we don't have jurisdiction to review that issue because that's a factual issue.
Well, all I'm saying is, if one looks at the lines and concludes they're not actually gerrymandered, that is to say they don't favor or undermine a political candidate or party, right? That you couldn't then find intent to do that. I mean, if you don't have that. Or again, am I misunderstanding the point?
I think if
I just want to understand if that's in part your point.
An intent that wasn't realized, it's hard to imagine how something like that could happen in this context.
I agree, which is why I think you always track back to looking at the district lines themselves. I guess I'm asking you if your argument is in part that the best evidence of intent is how the lines are actually drawn. There may be other evidence, but that alone would never carry the day unless you can show that the lines themselves end up with a gerrymander.
I think that's right. I mean, key evidence are the lines themselves, and I don't think you could call it circumstantial evidence. I don't think it amounts to anything in this case.
But the Constitution reads purpose, right? So I agree, a fact is very strong evidence of purpose, but it's not necessary evidence. Let's say we had a racial gerrymandering case, and we had statements, very offensive statements made, and I don't say this is this case, but, and that clearly indicated a purpose to marginalize certain voters. Would you say in that case, well, look at the map's okay? Like, it didn't do that, it didn't, so even though, you have a lot of these statements and you have some other smoke around the process, but no, it's okay because look at the map's okay.
Sorry, I didn't mean to suggest that the map would be dispositive if you had statements like that, and I think Your Honor's question points up exactly why this case was so weak on the congressional gerrymander, is that, all of the evidence was, the expert that they used at trial. I don't think the fact that, that the process didn't involve the Republican minority party really amounts to anything. I mean, that is simply not required by the Constitution.
But you know our case law well, and we've said when we look at the Constitution and its provisions, we construct it the way we would a statute, but in this case, with a constitutional provision, we're looking at the intention of the people, not the intention of the legislature. So we have two kind of different things going here, I think. Intent in terms of purpose to gerrymander, but intent in terms of what did the people think they were enacting. And if I look at the language that's on that ballot that says, this is a process that provides the legislature may only amend the redistricting plan according to established principles if the commission's plan is rejected twice by the legislature. That, to me, tells me the people of New York, when they voted for this commission, were under that impression. And that, at the time, those established principles, including a statute that said, even if you reject it twice, we're going to apply 2% rule for any amendments. And then they hear, no, 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 we have plenary authority. And I just ask you, do you think as we look at what was the intention of the people of the state of New York when they voted this provision in, was it that?
Well, I have a different view of that language, which is that what it shows is that, like the constitutional drafters, the people simply did not anticipate the type of issue that we had here, which is where the IRC deadlocked the second time around and then failed to submit a second set of maps. And, I would also add that,
So
four
if
of
there
the...
is, with the failure, with the second round, what is the remedy? If the procedure failed, as the people had envisioned, what is the remedy?
Well, the remedy is that, consistent with the legislature's historic authority over redistricting and consistent with the constitutional provision that allows the legislature a full and reasonable opportunity to cure when there's a legal infirmity, the legislature properly stepped in, and that's according to the 2021 legislation that was passed to fill precisely this silence in the constitutional procedures.
Do you know of any other law, counsel, that says if a certain officer or a certain person mandated with a duty under the state constitution fails to perform that duty, we're going to do X? Is there any other example of a statute like that? Because isn't that a way to say, well, if you don't do this, we'll do it. So does it set a different incentive here?
Well, I can't think of another statute, but what I think is important to bear in mind is that someone has to pass the maps, right? There's no choice. Someone has to pass the maps. So the question is,
that is charged under the state constitution has to do that. I mean, you're saying okay, but if you don't, someone else will do it. And I don't know of any other law that I read that way.
well,
If you don't fulfill your constitutional duty mandated by the Constitution of the state, well, we'll do it.
Well, I think it's just an example of the legislature foresaw this problem, and so it devised a remedy. And again, so the question is, who is going to remedy the problems? Would it be the legislature or the courts? And
Well,
I think if you accept...
in Section 4E, it certainly contemplates at least the court having a role. It talks about the court stepping in to remedy defects. So I guess it raises the question of, are we bound by the legislature's choice that they are the correct person to remedy, or the correct entity to remedy the defect? Or should we look to the language of the Constitution and recognize that the courts might have a role to play here too?
Well, the courts can certainly remedy a defect, but again, in Section 5, the legislature has to be given a full opportunity when there is a legal infirmity in the map. And again, what happened here, and I think this context is very important, because what happened was the IRC didn't have a quorum because 4 members refused to meet with the rest of the IRC. So again, 4 of the 5 judges of the appellate division actually rejected this argument. And so if the minority group among the 10-member commission could wrest this entire process away from the legislature and displace it onto the courts, and again, that assumes someone has a lawsuit. Maybe there are multiple lawsuits, and then how, multiple maps being drawn by courts, and then how is that resolved? So that raises
But counsel, if I can ask you, I'm on the screen, I'll ask the same question I asked the first lawyer. I'm having trouble seeing this as a true failure under the Constitution. Obviously, the IRC had an opportunity under the Constitution to label something as another redistricting plan, They could have submitted either or both of the first two they submitted again. They didn't do that, but as I read the Constitution, if one plan that's submitted is not adopted by the legislature, the IRC has, under the Constitution, the right to submit another one, so the legislature would have two plans before it. The legislature had two plans before it. It didn't adopt either. The Constitution is very clear that the IRC plans are not mandated to be approved. It's for the legislature to reject or accept. And once they've gotten two plans, what in many ways one can say is exactly what the Constitution anticipated, if the first one is not accepted, the legislature acted. I want to be clear. My argument has nothing to do with the Redistricting Act and the 2% that Judge Garcia refers to. I'm talking strictly about the language in the Constitution and that process. I'm not talking about a statute. I'm talking about the Constitution only. And I'm having difficulty seeing why the legislature could not, having had these two plans, move forward in accordance with 4B. Since when they deadlock on the first plan and they can submit the two highest vote gathering, or as many vote gathering plans that they have, as they did, you just track back to 4B.
Well, I suppose that is a possible argument. I mean, I think what was contemplated is that the IRC would submit a first set, either one or more competing plans. The legislature was then free to accept or reject them. And then if it rejects them, then the ball goes back to the IRC's court to submit a second set. And that set
Yes, but I think that in part is an optimistic view of what the IRC could do. And here the IRC is deadlocked, isn't going to move from that, but it does present two plans. And I don't see why then that is not enough under the Constitution for the legislature to move forward. Since the legislature doesn't have to accept any of it. I mean, it's sort of in some way, it's nice theory, but they don't have to accept any of it.
Well, all I can say is I believe that the legislature was with it because the legislature has the ability to accept or reject for any reason the two sets of plans, that the legislature acted well within its rights and consistent with the 2021 legislation in filling in what I think is a gap here to act when the IRC wasn't able to form a quorum and even submit a second set of
Is it a
competing
possible
plans.
remedy to send this back to the IRC to compel them to do what you say, and I think Judge Garcia thinks the people understood they should have done?
Well, I think if the court does find a violation, I think the proper remedy would be to send it back to, to send on the procedural issue. I suppose the proper remedy would be to send it back to the legislature, because under Section 5, whenever any map redistricting plan is declared invalid, the legislature shall have a full and reasonable opportunity to cure the infirmity. If the map wasn't enacted pursuant to the proper constitutional procedures and the 2021 legislation is invalid, then the legislature should have an opportunity to cure. Maybe that would involve going back to the IRC. I'm not sure, but again, I don't think that there was a
But if the council, if the infirmity is solely one of, let's assume for one moment, of procedure, that the IRC didn't, within the time frame set out in the Constitution, submit quote unquote a second redistricting plan, and if necessary a implementing legislation in accordance with that particular plan, the only entity that can cure that is the IRC. If the conclusion is the IRC has to do that, the legislature can't act until the IRC does that. What does sending it back to the legislature have to do with it?
If the conclusion is that the IRC has to act, then it needs to be sent back to the IRC. I don't think that's the proper conclusion to draw from what happened here, and I do think there's a big difference when the procedures break down. If it's the fault of the legislature deadlocks, then maybe it doesn't make sense to send it back to the legislature. But here, everyone agrees it was not the fault of the legislature. The IRC deadlocked because it couldn't form a quorum. And in that circumstances, it doesn't seem to me to make a lot of sense to say, well, then the legislature for the entire 10-year redistricting cycle has forfeited its ability to draw maps, and our only remedy is to have a court enact the maps.
Well, what would
That
be
would
the
make-
remedy, Counselor, if there's a substantive violation, if it's determined that there was gerrymandering? Does it go back to the ledge then?
It absolutely goes back to the legislature. If this court were to affirm and find that there was a substantive gerrymander, we disagree with that. But if this court were to affirm, then the legislature should have a full and reasonable opportunity, and we would ask for additional time beyond the April 30th deadline that the appellate division set for the legislature to cure, and that's in Section 5
Counsel, one
of the
quick
state
question.
constitution.
I'm sorry, would it be a full and fair opportunity to give the legislature the opportunity to submit its own proposed map to a special master to remedy whatever the problem is that is found in the event of substantive unconstitutionality?
I think the remedy would be a full and reasonable opportunity to enact a new map that would then be subject to review by Supreme Court.
So we have to start the whole process from the beginning.
Yes, and I believe that's a reason why a remedy should not be implemented in this election cycle. The election has simply proceeded too far down the road. So if this court finds a violation either on the substantive point or in the procedures, then it should lift the cloud of uncertainty that currently hangs over the election. There's a June 28 primary coming up. The designating petition period has already concluded, and it should declare that any remedy...
But counsel, doesn't that incentivize what happened here? Especially for those who might want the kind of outcome that they think they find in the lines as they were drawn?
It does not, and I believe there are three reasons why, and I know petitioners have argued that it does. I don't think you can say, well, we just can't trust the legislature because if they have one free pass, they will, gerrymander to their heart's content and know they can always get their incumbents in. And I don't believe that's correct. If there were an egregious gerrymander, a party could get preliminary relief. In fact, petitioners here asked the trial court to halt the designating petition process. The trial court declined to do that. And as a result of that, and in reliance on that ruling, the election has now gone forward. So that's not necessarily going to be the case in all elections. Again, we seriously disagree with the proposition that this was an egregious gerrymander. We don't believe it was a gerrymander at all. But in a different case, you could get preliminary relief. If you had a more limited challenge with only a small number of districts, it would be easier to implement a remedy. And finally, and maybe most importantly, the legislature is entitled to the presumption of good faith. I don't think you can simply assume that the legislature will manipulate the state constitutional process in order to enact a gerrymander.
Thank you, counsel. Counsel?
Thank you, Your Honor. Misha Saitlin. For the petitioners, I would also ask for 2 minutes of rebuttal.
On your cross-appellant, on your cross-appeal, you'll get your rebuttal time.
Thank you, Your Honor. In 2014, the people set up an exclusive process for how all redistricting maps would be enacted in the state. They also set up the strongest language prohibiting partisan gerrymandering found in any constitution in the United States. Yet in the very first redistricting cycle where this was relevant, the legislature ignored the IRC process, enacted a map as if that process wasn't in the
Well, in this
Constitution.
particular, the IRC process did begin, correct?
That's correct, Your Honor.
But there was a breakdown.
That's right. The process failed and there was a violation of law.
So is
And-
that the failure of the IRC or the failure of the legislature at that point?
Well, the IRC violated the law, and then the legislature attempted to take a step that it had no legal authority to take. The
So
Constitution...
could, counsel, I'm on the screen, so could petitioners or anyone else have sued the IRC if the IRC is the entity, in your view, that has failed to comply with its constitutional duty?
We could have, but the Constitution provides an exclusive, provides what happens when there's a violation of law by the IRC. It's right there in the same provision that says this will be the exclusive process. It says this will be the exclusive process, except that a court shall take a particular kind of remedy. And it's very important to read the Constitution.
Yes, but why isn't that remedy to require the IRC to comply with its duty? Why not just sue the IRC if that's the error, before you even get to the legislature passing any maps that you claim are unconstitutional, right?
Your Honor, the legislature had no authority to pass any maps, and the Constitution provides that a court is required to order the adoption or change to a redistricting plan as a remedy for a violation of law. The Constitution tells us what the remedy is for the violation.
Yeah, but what I'm saying is that the court's remedy for this particular error, I know you have another one on the merits of the actual lines drawn by the legislature. I'm not talking about that. For this particular error, which is or procedural defectiveness that you point to, that falls on the shoulders of the IRC for whatever reason. We'll just say that. And that if that's the error you want to cure, then the remedy has got to focus on that entity, and petitioners, or again, anyone perhaps, could have sought relief in that way.
Your Honor, the violation here also occurred by the legislature when it attempted to enact an unconstitutional map.
Let's just hold on to that
Yeah.
for a second. So what, in your view, should have happened when the IRC didn't submit a second plan? What's the next thing that should have happened?
The next thing that happens
No,
is that
should have happened. Yep.
the currently governing maps, the one adopted by the court in 2012 and the one adopted by the legislature for the state senate in 2012, are the governing maps. Now, someone could sue against those maps because they are malapportioned and unconstitutional. If that lawsuit succeeds because they are in fact malapportioned, then it becomes the court's duty to draw the map. But let's say the population hadn't moved. Let's say
Wait a
that
minute.
people were...
What about Section 5? That is, doesn't a right of the legislature spring upon judicial determination that a map is invalid?
Well, Your Honor, I have two answers for that. One is, as Justice Curran said below, the proximate provision to the procedural requirement is the one that said the court draws the map. But in any event, even if Your Honor looks at Section 5, you have to consider whether this is a violation that the legislature can cure. And here the violation...
Does it matter that the word shall have an opportunity? Does that verbiage matter?
Right, Your Honor.
As to giving them a chance to fix it?
But sometimes it is impossible for them to fix it depending on what the violation is. In this circumstance, this was not a violation that they could possibly fix because the commission did not have a deadline. And I just want to be clear.
Well, counsel, let me ask you this. Let me just, when you say there's no way the legislature could have cured this particular defect, so then the question is whether or not what they did if we can disagree with you on that and what they did is sufficient. And if indeed, again, I'd like you to address what I was asking about before. If the Constitution anticipates, if they don't accept one plan from the IRC, that the IRC gets a chance to submit another plan. And they did in this case submit two plans. And so the legislature has everything available to it that the Constitution otherwise would require. Why wouldn't this be, if there is some kind of defect, a very technical defect, why can't the legislature simply say, we not only looked at one plan, we looked at two plans, we don't approve them, and under the Constitution, we're not obligated to adopt them, we can reject them and then proceed with our own plan. Why isn't that an appropriate way to respond? And then all that happens is exactly sort of the rest of this litigation, which is whatever the legislature comes up with. If someone who's a citizen wants to challenge it, they can, and the courts will do what they usually do in these kinds of cases, determine that on the merits.
Your Honor, I have three answers to that question. One, this is adversarial litigation. That argument has been completely waived. Number two, as I read the Constitution, the second set of maps, or the second map that the Commission submits, has to be different from the first. That's why it's second. Third, even if I'm wrong...
But wait a minute, where does the Constitution say that? Where does it say that?
That, I think, is the fairest reading of the Constitution, that the second set of maps, after the first one was rejected, is different, because...
Well, let me ask you this. I understood your argument to be that the problem is they just didn't submit something by the second deadline, and couldn't they have submitted one of the other two plans that they had already submitted? Is your position now that they couldn't have submitted one of the two plans that they submitted on the first round? It has to be completely different from the other two?
That is not a position we've taken in this litigation because this argument.
No, but I'm asking you, given the argument you've just made, it seems to me that that is the logical conclusion, that they could not even go back and say, look, we were split on the two, now we have a quorum and a majority for one of these two, that's what we're going to submit. As I understand your argument, they couldn't even do that. They'd have to come up with something completely different.
That is my position standing here today, facing this argument for the first time, because the first two maps were both submitted by the legislature. But I think there's a third argument that I would like to finish, Your Honor, which is that the Constitution specifically says that the second set of maps shall be voted on by the legislature. It simply didn't happen here. They didn't vote on that second set of maps, even if Your Honor were to treat that as a constructive submission. So as a result, even this new argument, which again has been completely waived, very talented counsel, 3-1 throughout this case, no one has raised that kind of argument. So I think that in adversarial litigation, with respect, that argument needs to be.
So counsel, why wouldn't we just send it, it's a procedural violation, let's put aside the substantive for a moment. Why wouldn't we send it back to the legislature and say, okay, now vote on the original two maps? And if you reject them, then you can start this tail end of the process, which we can debate what that really means. But why not? Why isn't that the remedy here?
Well, Your Honor, because the Constitution provides the remedy. And the sentence says that the process for redistricting established by this section shall govern redistricting in the state, except to the extent that a court is required to order the adoption or changes to a redistricting plan as a remedy of violation of the law.
But that seems to be in some conflict with some later language. I think it's 5 or 5B, which says that they get a chance to correct.
Well, so Your Honor, I resubmit my three arguments that I just made to Judge Rivera, which is that this argument has been waived. Two, I do believe that the maps have to be different because if the legislature...
No, not different, but why don't we let them have a chance to finish under that provision of the Constitution that says they get another shot?
Well, the party that needs to submit the maps to the legislature is the IRC and the time frame in the Constitution.
Now this is a judicial remedy, and we're saying, okay, this was bad, go back and do it again.
Well, Your Honor, I think that that wouldn't be a judicial amendment of the constitutional time frame, which is lapsed at the end of February.
But so would be sending it to a special master, right? So what's the difference?
No, absolutely not, Your Honor. The Constitution specifically says that the remedy for a violation is the court adopts a new redistricting plan.
Shouldn't the remedy match the error? Shouldn't it address the error?
The remedy should be the one the Constitution provides. There's only one remedy the Constitution provides for a process violation, which is the adoption or changes to a redistricting plan. Now,
And you're saying the Constitution reads that the legislature is now cut out?
For the process violation, if we were to lose on the substance if we were losing on the process and win on our substance violation, I do believe that the questions the court asks are exactly right on. It is the only argument they could possibly have on an affirmed finding of fact is a sufficiency of the evidence argument. They didn't properly frame one of those, and in fact, there's no case that we have been able to find or my friends have been able to find in the history of the state of New York where an affirmed finding of fact was overturned based upon a disagreement between the experts.
Counsel, I just want to make sure I understand something that maybe I misunderstood you, but if you were to win on the substance, does the legislature get another chance under 5?
If we lose on the procedure and win on the substance, they have until April 30th.
Well, why April 30th?
They told the Court of Appeals that they, in this legislation, this is not a statute that's been discussed before, Your Honors. In this legislation, there is a provision that says that any decision by the trial court shall be tentative for 30 days. Mm-hmm. And they said to the Court of Appeals in seeking a stay, those are the 30 days that we need if we make a mistake to fix what we did, to do something new. So the Court of Appeals, in granting the stay and then ultimately in issuing the appellate division, in granting a stay and ultimately took them at their word. They
So
said,
you're saying that that's an agreed upon modification of the provision in Section 5 that springs upon judicial determination of invalidity.
so the Section 5 remedy, which allows the legislature a reasonable opportunity to cure,
You say they've cabined that by agreement.
they've told the courts, in fact, in seeking relief from the appellate division, what the reasonable period is, 30 days. Appellate division took them at their word, gave them the 30 days. That 30 days expires here in a couple of days. They can surely do it that quickly. In Maryland, when the map was struck down, also based in large part on Mr. Trendy's testimony, the court gave them, I believe, 5 business days, the Maryland General Assembly, and they enacted a remedial map in 4. And then what happened in that case, and I was hoping that would happen here after the 2 courts below had issued the decision, is the General Assembly in Maryland came together, passed a new map, Governor Hogan of the other party signed it, everyone agreed to end the case, and now there's fair maps in Maryland. That could happen very quickly.
Counsel, I see your time is up, but with the Chief Judge's permission, just so I'm clear, your interpretation of those 2 provisions is if it's a process violation, if the procedure set out for the IRC has been violated, then the court can send it to the special master, let's say, or take whatever action the court deems appropriate. If it's a substantive violation in terms of a purpose violation, then the legislature under Section 5 gets a chance to redraw.
A reasonable opportunity to cure. That's correct, Your Honor.
Thank you.
Thank you, counsel. Counsel, your rebuttal?
Yes, Your Honor. I think this case goes back to the institutional argument that I started with, and Mr. Saitlin makes clear his motivations over the course of his argument that, in fact, the objective of the petitioners is to try to push this task of map-making to a court and away from the legislature because his clients are not able to achieve, through the legislative process, the desired outcome that they want. And so, rather than give effect to the voice of the people as reflected by the legislature, who is elected by the people of the entire state of New York, to instead wrest away that redistricting prerogative and put it in the hands of a judge who is elected by only 0.5% of the people of the state of New York.
Sorry, go ahead.
Prior
Yes.
to the adoption of these amendments, the legislature was saying something different. In fact, they were saying that they wanted to amend the Constitution to reform comprehensively the process, to establish a new and exclusive process by which new state legislative and congressional districts shall be drawn, that will ensure the drawing of legislative district lines in New York will be done by a bipartisan independent body. So who's abandoning the will of the people now?
The commission did. The commission did its job at first. They submitted 2 maps at first, and then when they had the second opportunity, the commission did not do its job. And under this court's precedent in Cohen v. Cuomo, in a situation where there is a circumstance that's not anticipated by the text of the Constitution, we would submit that it is anticipated a fortiori because looking at Section 4B of Article 3 of the Constitution, it says, if either house shall fail to approve the legislation implementing the second redistricting plan, that's what happened here because there was no second redistricting plan, and so there was nothing to approve. It doesn't say if either house shall reject.
Counsel,
it says failure to approve.
That gets me back to the remedy question that Judge Wilson was probing before. Is there nothing anyone could have done when the IRC process was becoming derailed to compel them to act in accordance with their constitutional mandate? Or was this thing just supposed to completely, to torture the railroad analogy, was it supposed to just completely go off the rails and there's nothing anyone could have done about it?
I suppose that there could have been a lawsuit brought by petitioners against the members of the commission, but the time passed, and we would submit that in that situation, the ability to redistrict on the part of the legislature never went away because the commission was there to give recommendations. This is not a state like Arizona, for example, whereby the actual power to impose a redistricting map is placed with a commission that is separate and apart from the legislature, and the commission's determinations are binding. Here we had in New York State a commission that was entirely advisory, and any kind of map that may have come from that commission, the legislature was entirely free to reject. And when the commission did not do its job, then we would submit that, as has always existed for 2 centuries, the prerogative of the legislature to impose that redistricting plan.
Or perhaps counsel,
And when the commission didn't perform their job, what recourse, if any, did the legislature have?
The legislature's recourse was to go ahead and propose a new map and enact a new map, and that's perfectly consistent with the language number 1 of Article 3, Section 4B, because neither house was able to approve a new map, and second of all, inasmuch as it could be determined that the Constitution is not simply on point with respect to what happens when there is a failure on the part of the commission, not a failure by the legislature, a failure by the commission to do its job, then it was the prerogative of the legislature to enact a map, and that's exactly what the
But
legislature
counsel,
did.
why, if I'm on the screen, why isn't your adversary correct that what happens in that situation is that the existing maps stay in place, and of course, someone could challenge them if they wish to say that they are malapportioned,
Well,
to argue that they're malapportioned. Why isn't that the way it should work? Why isn't he right about that?
Well, with respect to the congressional map, there was no way that those maps could remain in place because there was a reduction in one seat of representation in Congress. And so with respect to the judicial remedy that Mr. Zeitlin speaks so highly of, I think that question is answered by Section 4E of Article 3 of the Constitution, which says that this process shall govern redistricting in this state except to the extent that a court is required to order the adoption of or changes to a redistricting plan as a remedy for a violation of law. And we would submit that there was no such requirement here because the legislature acted, and as this court noted only 35 days ago, judges may not arbitrarily supplant the legislature's reasoned determinations with their own judgments or notions of common sense under the guise of constitutional interpretation. And that's precisely the same case that we have here again, because the legislature balanced all of these required factors under Article 3, Section 4C5 of the Constitution, and maybe the petitioners would have drawn the map a little differently. Maybe someone from a think tank or from an editorial board of a newspaper would have drawn these maps differently, or somebody on Twitter might have drawn these maps differently. But the fact is, they are not the legislature, and they are not elected by the people, and that's why all these maps should be upheld.
Thank you, counsel. Counsel?
Your Honor, we're glossing over the language of the Constitution. Mr. Salen purposefully omits, when he reads from Section 4E, the words "and Section 5," which are incorporated expressly into 4E, and use the word "any" twice. Is this any judicial proceeding relating to redistricting? And are we talking about any law establishing congressional or state legislative districts? Because if we are, the legislature gets the opportunity not to present a plan to the special master to correct unilaterally its infirmities. And if that's incorporated into 4E, then it's impossible to conclude at all, let alone beyond a reasonable doubt, that it unambiguously extinguishes the legislative authority, even though when the League of Women Voters was urging a decade ago that this state do what Colorado and Arizona and Michigan did, which is give the commission sole authority to enact, the voters didn't do that. And the legislature, which is the ones that proposed the 2014 amendments, didn't do that. They're purely advisory. I want to come back to the substantive point and make what I think is a critical observation about what's going to come next. If this court accepts petitioners' invitation to be the first court in history to ever strike down a redistricting plan without paying attention on a district-by-district basis to what the justifications are and whether they are persuasive, and if not, why not? What is the legislature supposed to do, whether it's in a few days or an extended period of time, for example, with District 11? We have put into the record unrebutted evidence that adjoining District 10 was drawn the way it was in order to reunite the Chinese American community that had become cracked. And as a result, it just so happens that District 11 had the composition of its partisanship changed. If this court strikes down, as the trial court and the appellate court did, the plan without telling us anything about which districts are infirm and why, what are we supposed to do with District 11? In the absence of a specific judicial order, are we supposed to go back and purposefully recrack the Chinese American community for the sole purpose of rendering the adjoining Staten Island district more Republican? That would be deeply problematic, and that's why courts don't do that. The Florida court, where the process was so dramatically more problematic than it was here, noted the extremely serious process failures and then went through in numerous opinions and numerous rounds of litigation, district by district, and said, here's the problem. And by the way, upheld almost all the districts in the end. And the couple that were struck down, there were specific instructions, and the legislature fixed it. This gets back to the problem with Mr. Trendy's methodology. It's literally incapable. Forget about accounting for communities of interest, which explains all the deltas in all of his bands, it doesn't even tell us which districts we're talking about. In his singularly important dot plot chart, those districts aren't the districts. They are the ordered districts in which his simulations come up most often. We don't even know for sure what the first 4 districts are or what the next 9 are, and I just would respectfully...
Counsel, just to be clear, no one moved to preclude Mr. Trendy's analysis on the grounds that it was methodologically deficient or anything like that, did they?
Correct, but we expressly acquiesced in his testimony subject to cross-examination. That's literally what was said in the record. And then we cross-examined him and showed him to be, his methodology to be worthless. This was a bench trial that happened very quickly. There was no expert discovery. The court said on the record, I want the experts to come so I could see who's gotten it right and who hasn't. And everybody testified and everybody got cross-examined. I would respectfully suggest that it would be deeply problematic to strike down a statewide redistricting statute, notwithstanding all of the evidence of the methodological failures, because there wasn't some kind of foundational objection that wouldn't have been appropriate under the circumstances.
Thank you, counsel.
Thank you.
Counsel?
On the issue of the standard of review, I mean, petitioners again say these are affirmed findings of fact, but I would just remind the court, you're not writing on a blank slate here. I mean, there are 3 redistricting cases, matter of Sherrill, Schneider v. Rockefeller, Walpole v. Cuomo, and in those cases did involve review of what could be called factual issues like the compactness of the districts, contiguity of the districts, and in none of those cases did this court suggest that there was anything other than a conclusion of law that was at stake. Nor did this court view it even as a sufficiency of the evidence, although I agree that would be preferable to...
Counsel, do you agree that any action this court takes would have to be premised on a district-by-district analysis, no matter what the constitutional districting violation might be? So whatever the purpose overall, this court, I hear, unlike any other court in history, we would not have the authority to strike a map. Do you agree with that?
Well, I mean, I think it could potentially depend. I mean, it's very difficult unless you have a district-by-district finding. I mean, this isn't an argument that the governor's made, but I understand the problem. It makes it very difficult to cure unless you go district-by-district because you have this issue of communities of interest.
And I just want to go back. That would also depend on where we sent it, right? Because if we sent it to a special master, then you wouldn't really have that problem to draw a new map.
Well, I mean, I suppose unless you know which districts are invalid, I mean, as I understand what petitioner wants is that a new map needs to be drawn up from scratch. I want to briefly address the procedural issue and just 2 quick points on that. I mean, one is that even if there's any way to reconcile the Constitution with the 2021 legislation, that it should be done. So even if what petitioner is arguing is a possible argument, it shouldn't carry the day. I think a more reasonable reading of the state constitutional procedures, when you look at the issue in context and in the context of the legislature's historic redistricting authority that was not changed with the 2014 amendments. The legislature retained an enormous amount of authority under the 2014 amendments that the legislature appropriately stepped in here. And that, again, there's a big difference between when the problem is, when the legislature is the source of the problem, then maybe your only option is that a court is required to step in. But that's simply not what happened here. The IRC was prevented from forming a quorum, so it couldn't even submit a competing set of maps. So the legislature acted within its rights in stepping in and drawing maps.
Thank you, counsel. Counsel?
Thank you, Your Honor. The process that the 2014 amendment sets out is for the enactment of new maps. And it is a legal predicate for the legislature to do what it did before, which is bicameralism presentment. If the process fails, then the old maps are in place unless somebody brings a lawsuit. If someone brings a lawsuit, court draws them out. That resolves all of the concerns about how to structure the remedy. Now, in terms of the timing,
How do you keep the old map for the congressional districts in place when you don't have as many congressional districts?
well, somebody we need to sue, and we did sue, and it's very important that in our lawsuit, we challenged not only the new maps, we challenged the old maps, because we recognized those were malapportioned and had the wrong number of districts. So we did that here. We did that job here, and I would respectfully submit, given the stakes of redistricting, how many people are impacted, you're always going to have a lawsuit. But the way that the structure works is that you just can't enact, there's no let's say you had a really static decade, and people didn't move around, especially in the state assembly, in the state senate, where you didn't need to redraw it. If the process failed, then the maps from the prior decennial would just control. There's really no problem there. If there's people moving, you're always going to have a lawsuit because of the stakes involved. And then
But that
finally,
does, counsel, I'm on the screen, but that does seem to be not really what the Constitution is attempting to do, because again, they are correct, you can't deny that. They are correct that the IRC, the Constitution doesn't mandate that the IRC plan or plans be adopted. It is always the legislature's province to reject or approve the plans, and if they don't, then they can pass their own. I'm again having difficulty with your argument that you're driving the substantive work of drawing district lines into a judicial forum when it's very clear that the legislature doesn't have to adopt what the IRC proposes, and the legislature gets to cure any infirmities with the legislation or with the process. I'm having great difficulty with this argument that you are making that throws it to the court. And by the way, when you said it just goes to the court and then the court fashions its remedy, again, the Constitution makes very clear that the legislature has to have an opportunity to address those district lines that you claim are violating the Constitution in the way they've been drawn.
may I answer?
Yes, please.
As the League of Women Voters explained, the judicial backstop, which is the only remedy for judicial violation, derives the compromise. If the legislature knows that if it appoints IRC commissioners that will not do their job, they will do a good job appointing commissioners that will compromise. If your honors accept the arguments of my friends, the IRC is over. The legislature will never bother appointing commissioners again, or they'll appoint people whose only job will be to deadlock the thing. If, however, this court does what
Or counsel, it could very well be that the people of the state of New York will recognize that their attempt to provide a way to address gerrymandering and other problems that the people of the state of New York may view as somehow embedded in the current process requires a true independent IRC that is one that is not merely recommending plans, but is actually deciding what the lines should be.
May I, Your Honor?
Please.
The people in 2021 were asked by the legislature with a constitutional amendment, can we do this very thing? If the IRC fails, can we enact a map? They put it on a constitutional amendment. The people said no. It would be a grave insult to the people to tell them that their votes in 2021 were entirely irrelevant.
Counsel, even going back to 2014, it seemed to me, looking at the debate, that there was a position that said don't vote for this by certain good government groups because it's sham reform or it's, and then there were some other groups that said no, this is real. So it seems the people believed this was real reform at the time, so that we would be telling them at this point that no, it wasn't.
Absolutely, Your Honor. Thank you.
Please. Thank you.
All please rise. Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals held in and for the state of New York may depart hence and appear here at the next scheduled session of this court, to which time this court now stands adjourned, unless sooner convened by the Chief Judge or the Senior Associate Judge present in this state.